Hello, fellow teens. Today we'll be talking all about the law. I know, that's boring, right? Wrong. The knowledge and understanding of the law is extremely important so that you know your rights and have a better understanding of what you can and cannot do. It can also help you not be taken advantage of. All right, let's dive right in. Just so you know a little bit better what we're going to be talking about, here's a table of contents of all the content and information we'll be going through, all starting with why law is important. So, what is law? Why is it so important? Well, law can be described as a system of rules created and enforced through social or governmental institutions to regulate behavior and actions. Law is extremely important in the world as it helps keep the peace and it protects its citizens. Law protects by giving order and safety. For example, laws against murder and stealing keep your life safe. Labor laws keep you safe and fairly treated in the workplace, and civil laws keep you protected in disputes, and so on and so forth. Let's start first with a brief history of law. One of the earliest and most complete written legal codes from the ancient times is called the Code of Hammurabi. The Code of Hammurabi is a collection of 282 rules that were created by the Babylonian king Hammurabi in 1792 BC. These rules and standards outline consequences for different actions and were carved into a large finger-shaped stone pillar. The main feature of the Code of Hammurabi is that it is one of the earliest examples of the laws of retribution, sometimes referred to as an eye for an eye. It was also one of the first laws to consider someone innocent until proven guilty, which is now a cornerstone of modern law. Next is Mosaic law. The Mosaic law is given in the first 5 books of the Hebrew Bible and contains 613 laws. The law starts with the 10 Commandments, which are a set of well-known laws in many religions. Lastly, there's Roman law, or the law of the 12 tables. These laws, as the name suggests, were inscribed in 12 bronze tablets, each focusing on a different topic, such as land rights and court procedures. There are many other ancient law systems out there, but these 3 were the most influential in forming the modern law and the court system as we know it today. Now let's move on to one of the most important aspects of law in Canada, the Canadian Charter of Rights and Freedom. This charter came into act on April 17th, 1982, and sets the basic rights and freedoms everyone is entitled to. It also gives Canadians the right to challenge abuses of said freedoms to the court system. The charter is made up of 5 basic rights and freedoms: the freedom of conscience, freedom of religion, freedom of thought, belief, opinion, and expression, which includes freedom of speech and of the press, freedom of peaceful assembly, and the freedom of association. These freedoms help keep equality and fairness in our society and are a cornerstone of life and law in Canada. Next, we're going to talk about the 2 basic divisions of law, public and private. Private law deals with disputes and cases between individuals or companies. An example of private law is if someone sues someone. Private law breaks down to 5 divisions: family, contract, tort, property, and labor. Public law is disputes and cases between individuals and the government. Anything from murder to disputing a speeding ticket is public law. Public law breaks down to 3 main groups: criminal, administrative, and constitutional. Up first, we'll talk about private law and what its divisions are. Family law, as the name suggests, deals with disputes within the family, such as divorce or other domestic relations. Contract law deals with the violations or questioning of legally binding contracts. Most commonly, these cases are between employees or landlords and tenants. Tort law deals with cases of civil wrong that cause the claimant to suffer loss or harm in any way that makes the person who committed the act legally liable. The most common form of this is when someone sues someone else. This usually means the person suing feels the other should be legally liable for their actions and need to provide compensation. Property law is an area of law that oversees the rights, duties, privileges, no rights, powers, liabilities, disabilities, and immunities that people have in regards to physical or intellectual property. And lastly, there's labor law, which deals with relationships between workers and employees and the rights and entitlements of each. After this comes the divisions of public law. Up first is the most well-known portion, criminal law. Criminal law is the part of the law that deals with crime and its punishments. Any offense that is threatening, harmful, or endangers the property, health, safety, and moral welfare of others is classified as a criminal offense and is punishable as such. Administrative law deals with the law that governs the proceedings of executive levels of governments. This law oversees rulemakings, adjudication, and law enforcement. Constitutional law is a body of law that outlines the powers that executive, legislature, and judiciary members have and the duties and rights of citizens. See, law isn't that hard to understand, right? Hey, hello, yeah, you, wake up. Thank you. Now that I have your attention, let's move on. Now that we've gone over the divisions of law, let's now talk about the different kinds of offenses. The three offenses that exist are summary, indictable, and hybrid. Summary offenses are petty or less serious offenses. These kinds of offenses usually are resolved without a jury. An example of this would be traffic violations or minor shoplifting. An indictable offense is anything major and serious. This includes murder, sexual assault, and many other major criminal offenses. Indictable offenses usually require a jury and have far more severe punishments. A hybrid offense is an offense that could be prosecuted as a summary or indictable offense. This decision is usually made by the Crown. Now that we know all about divisions of law, let's now get into the main factor of convicting people of crime. The terms we'll be looking at are Latin terms and are extremely important in determining guilt. These terms are actus reus and mens rea. Actus rea, which means guilty act, refers to the act of the crime itself. In court, the Crown must prove that there is actus rea, meaning they must prove that the accused actually committed the act. The second term, mens rea, or guilty mind, refers to the intent to commit the crime. This one's usually a bit trickier to prove as we can't read minds and can never fully understand why people commit the things they do. Either way, it is still possible to reasonably prove intent given the situation and evidence around each case. These two terms are extremely important because without intent, the crime committed will always be treated and punished less severely than if the person had full intent to do it. So we've talked all about the different areas of law and crime now, but what about where everything is processed? This is where the Canadian court system comes in. In Canada, we use the judicial branch court system. This means that the Supreme Court is the highest level of court, and it then further subdivides into everything else. Together, all these different courts decide the outcome of every case of dispute in Canada, each advancing up to higher courts as necessary. No matter the level of court, however, all must follow trial procedure. There are four main steps, starting with the first appearance. This, as the name suggests, is the first time the accused appears before a judge. After this comes pretrial. The pretrial is a meeting between the defense, the prosecution, and the judge before the main trial takes place. After this comes the main trial. Here, evidence is presented, facts of the case are gone over, documents are shown, and witnesses may give testimony. This, of course, varies by trial. And lastly, there's sentencing. This is where the court reaches a verdict and either decides that the accused is innocent or they are guilty, and a punishment or sentence is given. As you know from the title, this video presentation is targeted towards teenagers and youth. So, how likely are you to commit a crime? Statistics show that 13.1% of all crimes committed in Canada have been by youth aged 12 to 17. Statistics further show that 6% of Canada's youth population will be accused of committing a crime. Youth are an integral part of our society, and as such, more focus is spent on rehabilitating offenders rather than locking them up in jail. 58% of youth offenders were dealt with through alternative means, either through parole, rehab, community service, fines, or warning. This helps ensure offenders do not reoffend, while also keeping them out of jail. Although subtle, the effects of these programs can be seen. Between 2000 and 2010, youth crime rates per 100,000 kids has dropped from 7,000 to 6,147 and is continuing to drop each year. Understanding legal terms and jargon can be very tricky, I know. The best way to better understand Canadian law is to get comfortable and familiar with these terms. There are far too many to list for the purposes of this video, but the Ontario Women's Justice Network has a wonderful website that outlines them all and what they are. So, if you feel you need more help understanding Canadian law, I recommend you'd head on over there. Well, that's all I have for you today. Thanks for watching, and I hope you enjoyed learning all about the basics of Canadian law.